Welcome, welcome, welcome. Good morning to those of you out west. Good afternoon, good afternoon to those of you out east. My name is Dan Balkaran, and I'll be your employment lawyer for the next half an hour. I'll be fielding all your questions, employment law. As I said, my name is Dan Balkaran, and as you can see on the bottom there, I'm an employment lawyer at Samfiru Tumarkin, Canada's leading employee-side employment law firm. A couple housekeeping matters before we get started. If you need to reach us, you can do so at employmentlawyer.ca, help at employmentlawyer.ca, or 1-855-821-5900. Okay, so while we're waiting for the questions to roll in, it's starting to change a little bit, but the bulk of the questions, and by bulk I mean 98% of them that you've provided, have been about vaccine mandates, and I'm not a big fan of that term, and I'll explain why in a second. But really just to simplify it, it's the questions have been regarding people who have been told by their employers they're going to lose their jobs if they don't get a vaccine, and they don't want to get a vaccine, and then they end up either being put on unpaid leave or they end up losing their jobs entirely. So there's a substantial number of people who this has happened to, and really most of the questions I've been asked have been about that. So I'm just going to cover off a little primer on that, and then I'll answer your questions as they roll in. So and I do say this every time I do this session with you guys, but a vaccine, like if your employer says you must get a vaccine or you're going to lose your job, that is a vaccine policy from the employer. And if there's nothing in your contract that says you're required to get a vaccine in order to continue working there, and they never had this policy before and you never agreed to this policy, then the vaccine policy, then it's very likely that you're entitled to severance, and depending upon your legal position, your severance could be very lucrative. The maximum severance that someone would get is depending on their age, length of service, nature of their employment, and availability of similar employment is and their what their employment contract says is 24 months. So it could be quite substantial. So in the event that your employer says you're fired because you didn't get a vaccine, it's entirely possible that you have severance coming to you, and you should have severance coming to you, and then how much severance you get is pursuant to what your legal position is. Okay, what a vaccine mandate is from the government is it is a properly papered law. Usually it's a provincial health order, but it can be a law. It can be, like I said, a provincial health order, something that's properly papered from the government or from the federal government, depending on if you're federally or provincially regulated as an employee. And that gets really complicated, so I'm not going to go into that. But a properly papered law which says in order to work as an employee in this sector, you must be vaccinated. In a situation like that, that's a government mandate, and that's where the word mandate properly applies. In the situation of a government mandate, your right to work in that job is effectively extinguished, eliminated, and your right to severance is extinguished. And then the federal government administers employment insurance, EI, through Service Canada. They have said you also lose the right to get EI. So in one stroke, if a government mandate applies to you, and you would know because there haven't been any new mandates in a while, for the most part, then you lose your job, your right to severance, and your right to EI. So you go from financially viable to having no cash flow whatsoever, overnight, which is a pretty serious thing. So that's the difference between policy and mandate. The only other thing I'll say, employer policy and mandate when it comes to the vaccines, the only other thing I'll say before we get into your questions, what seems to be happening with a lot of employers is that they're putting unvaccinated employees in a state of unpaid leave. They're not just terminating. And why does this matter? Well, all of your legal rights effectively flow from termination. Your only legal right in the event of your termination is severance. And so in order to get severance, you have to be terminated. And so what these employers are trying to do is they're kind of hedging their bets. They're putting you on an unpaid leave, which doesn't trigger your severance rights, or at least that's what they're hoping for. And will the COVID climate change? Will COVID abate enough that they can get rid of these vaccine mandates and bring you back to work. Like they're kind of keeping their options open as best they can. So for most of you, the vast majority of you, there is no contractual right. Your employer doesn't have a contractual right to suspend your pay like that. And when they do that, you're effectively been constructively dismissed if you trigger your constructive dismissal. So what is a constructive dismissal? Constructive dismissal is a unilateral change to a fundamental term of your employment imposed upon you by your employer that you don't agree with. Now, what that big log sentence means is, well, I'll give you an example. It's probably easier just to see what the example is. Your employer, if they were to unilaterally lower your pay by 20% or 50%, that would be a constructive dismissal because it is effectively unilaterally changing the terms of your contract in a non-trivial way, and that effectively, they're signaling to you that they no longer want to be bound by the terms of your contract of employment. Well, stopping paying you altogether is they have no right to do that, and so at that point you then have you've been constructively terminated. But in order to, and you have severance that would flow from that, but in order to get constructive dismissal, or in order to claim constructive dismissal, you have to advise your employer that you consider their actions a termination. Before you do anything like that, you need to speak to an employment lawyer. And so now's a good time to remind you all that you can reach us at employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, now to get into your questions. Let's see here. I don't know this person's name. I'll just answer their question. So, pardon me, excuse me for 1 second. It's extremely warm. I'm working from home today, and it's extremely warm in my my apartment for reasons that I'm not quite sure of. Bear with me. Thank you. Okay. Are you only eligible for severance if you have worked for a company for a minimum of 5 years or more? No. So you are entitled to if you have a legal entitlement to common law severance, and that's going to flow from your employment contract if you signed one. If you have a legal entitlement to common law severance, you have a legal right to severance the moment that you sign that contract. Okay. If you do not, if your contract limits you to the Employment Standards Act minimums, then you have a legal right to what's in the Employment Standards Act in terms of how much severance you're entitled to, but that's generally 1 week per year of service. And you don't, I mean, I think it varies by province, but certainly in BC, which is where I'm called, you don't have a legal right to the Employment Standards Act minimums until after 3 months of service, but certainly not 5 years. At 5 years, you're going to have, in most provinces, if you're provincially regulated, which is 90 to 95% of employees out there in Canada are provincially regulated, you'd have an entitlement to at least 5 weeks of severance at 5 years. And if you had if you were entitled to common law severance, you'd be entitled to substantially more at that point, closer to 5 or 6 months or whatever your legal position dictated. And again, given the question you're asking, you certainly should speak to an employment lawyer. Reach us again at help@employmentlawyer.ca, 1-855-821-5900. Okay, Lisa asks, what about if a person has a union and is waiting on an arbitration? Lisa, you need to speak to your union representative. If you're waiting on an arbitration, it sounds like your matter is being properly dealt with. And so much of union matters, are dealt with at arbitration. But your rights as a non-unionized employee flow from your employment contract. Well, your rights as a unionized employee flow from your collective bargaining agreement and the various labor relations acts that apply to unionized employees. And so, you need to speak to your union representative to find out exactly what your rights are pursuant to your collective bargaining agreement. Flo asks, my employer is still requiring me to take the vaccine after I already had the first one and had a bad anaphylactic reaction and was provided with a medical exemption. I'm on unpaid leave. Yeah, so I have a few clients in very similar situations. I've talked to a number of people who have had anaphylactic reactions. They're worried about that they might die. People who, I don't want to talk about what their reactions were, but there were a severity of reactions that I was certainly surprised by, and they would have notes from their doctors or just testimony as to how serious the reaction is and how they were afraid to get the second shot, and their employer fired them anyway. So I think that, well, first of all, Flo, you're still working there, okay, and so you're on unpaid leave. Okay, so you're on unpaid leave. You can treat that unpaid leave as a constructive dismissal. Whether or not you're going to want to do that is contingent to a substantial degree on, are you ever going to get the vaccine? Are you going to get the vaccine? Will you ever go back to work there? Consider going back to work there? And what is your legal position with respect to your severance? Flo, you 100% need to speak to an employment lawyer to find out what your options are first before you do something, right? You don't want to take action before getting in, employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900 to get a hold of us if you'd like. But you don't want to take action unsupported by legal advice, because you might do something that harms your legal position that someone like me can't get you out of, right? It's much better to talk to a lawyer first, have us shape your actions so to put you in the best position for whatever it is your objectives are. And Flo, so you need to decide what's important to you and what your objectives are. So the example I always use, if you're 53 making $85,000 a year with no university education, you can't lose your job, because you're going to come back into the employment market and you're not going to get anything close to what you had before. And so you need to figure out some sort of accommodation with your employer, be it you work remotely or, what have you, or you stay on unpaid leave for a little while. And maybe, there seems to be a sea change happening right now across the West in terms of how we view vaccine. It's coming late to BC, but how we view vaccine mandates and restrictions and living with COVID itself. And so, if you need to preserve your job at all costs, maybe if your employer leaves you on the unpaid leave for a while and then it changes its policy in 6 months or a year, then you can go back to work. Although I know that's a very long time, and especially because you won't be able to get EI because you refuse to get the second shot of the vaccine. But you're in an awful position, Flo. Like, you have to decide between, well, I could die, if I get the second shot, versus losing my job, right? I think as far as if you want to pursue severance, obviously talk to an employment lawyer. If you're entitled to common law severance, your facts are very sympathetic. I would imagine a court's going to want to help you, especially if you get proper medicals. And so that's something. You said that you provided with a medical exemption. You want to have your medical ducks in a row here. You want a doctor's note that you provided to them saying it is unsafe for Flo to get the second shot. We just don't know how she's going to react. She almost died after, she had an anaphylactic reaction to the first shot. You want this properly papered. You want evidence of you providing those notes, requesting an exemption to your employer. You want all of that properly documented, because that's going to assist you greatly, and it will help the court find that you are entitled to severance. So certainly you want to do that. You're going to want to do that in coordination with a lawyer for sure, to make sure that you get all of your medical ducks in a row. If you're on unpaid leave, you can trigger, and you don't want to let too much time go past. Technically, when there's a unilateral term imposed upon you that you don't agree with, in this case, they stop paying you. So, you're not allowed to go to work. That's a fundamental change to your employment. Technically, you have 2 to 3 months in BC anyway to claim your constructive dismissal. The law is a little fuzzy on that, but you want to move, especially with an interruption in your pay. You want to move faster rather than slower, because technically under constructive dismissal law, after a certain amount of time, you're deemed to have accepted the change. If you don't protest the change that's been imposed upon you. I think it's a little different with with an unpaid leave, because they just stop paying you, so you've effectively been terminated anyway. But still, you want to move quickly rather than slowly. Talk to an employment lawyer. Again, help@employmentlawyer.ca, 1-855-821-5900. And just decide, what's important to you. Is it your job? Is it there's no way you can take the vaccine, or an alternate vaccine? And then once you figure out what your hard positions are with respect to your job and the medicals, then you can tailor what your legal strategy is according to that. But I would certainly do that with a lawyer, depending on your legal position, right? Like if you don't have any right to common law severance pursuant to your employment contract, then you've got, you're looking at triggering constructive dismissal for, a maximum of 8 weeks of severance, which is, a poor exchange for poor trade for losing your job. So, Flo, you have my deepest sympathies, and I wish you all the best as you navigate that difficult problem. Randolph, I've been working a seasonal position for several years now, and recently been notified I won't be hired back. I do have another job as well, but am I owed severance for seasonal work? So seasonal work is there's two parts to your question, Randolph. Seasonal work is a tricky one because it's not, if you were a seasonal logger, and we have a lot of forestry employees in BC, and forestry employees are all seasonal. They have an 8-9 month year, and if you're a seasonal employee and you do that for 10 years, it's not just a matter of, and you had no employment contracts, you're entitled to common law severance. It's not just a matter of 1 month per year of service because you're a seasonal employee. And so, it's still an assessment of reasonable notice, but it's reduced to the extent of your seasonality. It also matters when your termination happens, right? So if they terminate you at the beginning of the season, most likely, depending on how long you were there, the result is going to be that you get severance for the season if you're entitled to common law notice, whatever the season would have been. But if you were terminated right at the end of your season, then your your off season cuts into your severance period, and so it would be much smaller. So seasonality is a really tricky one. Certainly, you want to talk to an employment lawyer about that. Help at employmentlawyer.ca 1-855-821-5900. The second part of your question is common to all terminated employees seeking severance. I have another job as well, but I'm owed severance for seasonal work. If you got the job so the purpose of severance is to tide you over until you get your next job. It's not a windfall. It's bridge money to get you from here to the next job that paid you the same. Okay, so what that means is you're not entitled to double compensation. Any money that you get from a new source of income, no, that's a bad way to put it, from a new job, from new employment, after you've been terminated, is dollar for dollar deducted from what your severance would be during the notice period, during your severance period, whatever that amounts to, right? So let's just say you're entitled to 6 months of severance, but after 1 month, you found a job that paid you the same, and you worked and you had that job through the 6 month period. Your severance is effectively 1 month, depending on what the Employment Standards Act says. But I don't want to get into. I don't want to confuse the issue. So the new job, if you got it following your termination, is dollar for dollar deducted. So if it pays you more, your severance is limited to the period of time you were unemployed for. If it pays you less, your severance is limited to the period of time you're unemployed for, plus the difference between the new job's pay and the old job's pay across whatever your severance entitlement period is. I know it's complicated, but that's what it is, and then it's aggregated together. But if the job that you have, because you said you have another job as well, if you had that job prior to losing your job, then it's not deducted. The money that you're earning at the job the second job is not deducted from your severance because you had that job going into your unemployment. However, any increase in pay that's a bad way to put it, any increase in hours resulting in more income at the second job that occurred after your termination, that increase would be dollar for dollar deducted. Okay, so I know there's a lot of, I gave you 3 different components of that, but it's not clear from your question exactly what you're asking. But seasonality, very complicated. Speak to an employment lawyer. And it matters when you were terminated. Your severance, if your new job was after your termination, then your second job was after your termination, that's dollar for dollar deducted. Okay. Question from Katie on Facebook. Can you fight WorkSafeBC decisions with partial disability, i.e. monthly payout amounts? Yeah, you can fight WorkSafeBC decisions but it's going to be very difficult for you to get a lawyer involved because not many lawyers practice in that area, but that's mostly B, because there isn't any money in it, to be perfectly blunt about it. And so there are a handful of lawyers that do WorkSafeBC work of the kind that you're talking about, to try to increase your monthly. I think that's what you're asking for, is you want a bigger monthly payment. There are certainly lawyers that do that. If you want to send me an email, you just look up my name, Dan Balkaran, which will get flashed on the screen. There it is, or it'll flash on the screen shortly. If you look up my name, Dan Balkaran, my email address is there. Shoot me an email, and I will refer you out to some lawyers who do work in that area. Okay, Hannah asks, can union members legally hire an employment lawyer if their union refuses to act on their behalf? So this is outside of my scope of expertise. I don't do any union side work. I will say that talk to your union rep. Obviously, if they refuse to act on your behalf, there are some labor lawyers that do employee side work. The vast majority do work for the employer, but they either work with the unions, I should say, and work, or they work for the employer. It's rare that from my understanding, that labor lawyers work for individual employees who don't agree with what their union is saying. But certainly they are out there, and I'm sure that we can. I don't know what province you're in, but if you Google it or if you contact us, I'm sure we can have a referral out for you. But it's not really a common thing from my understanding, and I can't really advise you on that because I don't have a good handle on exactly what you're asking. So sorry about that, Hannah. Flo is back. Flo is the one who had the anaphylactic reaction to the first vaccine. They will fire me if I don't get the second shot by March 14th. Yeah, Flo, I don't know what province you're in, but you need to talk to a lawyer right away. You should give us a call, 1-855-821-5900, and just figure out exactly what your legal position is. If you've got a huge severance day coming to you, you're like a 25-year employee and you're 55 years old and you're making decent money, that's one thing. But if you have an employment contract that limits you to Employment Standards Act minimums, that's another thing. So definitely contact us right away, or any employee side employment lawyer right away. You absolutely need legal advice, and you need someone to go over your legal position with a level of specificity that I can't do right now, Flo. So question on Facebook from Sandra. What are employees' rights if they are found to be participating in an anti-mandate protest? I actually did an interview on this recently. So on the radio, I think it's posted. If you guys want to take a listen to it, it's on that exact question. If you go to our website, employmentlawyer.ca, and you click on the blog tab, just scroll back a couple weeks, you'll find the interview that I did on the radio about this specific question. So it'll go into it in more depth than I can do here. The short answer to your question, Sandra, is we have not yet reached the stage in Canada where you are convicted or liable on the basis of your political beliefs or your character. Okay. And so what I mean by that is, if your employer fires you for being at an anti-mandate protest, you're going to have a right to severance. That simply being at a protest is not tantamount to just cause, or it is not just cause for your termination, at least not yet. Okay. The employer would argue that it was a single act that was so egregious that they were justified no longer continuing the employment relationship, because you being visibly at the protest, maybe on camera, on the news, or whatever, is hurtful to the employer's reputation, and therefore they had to do it. I don't see merely showing up at one of these things to be such that an employer could terminate you without paying you severance. But, and this is something that I've got to be crystal clear about. If you've got an employer who's sensitive to these things, and you show up on the news or on social media, loudly at one of these protests, they might fire you. You need to think about that. Now, do you have a right to severance? Yes, but you don't want to lose your job, or you probably don't want to lose your job, because that upends your whole situation. So your financial situation. So I mean, you got to think about that strongly. I will say this though, despite what I just said, aggravating circumstances can make a just cause. So if you commit a crime at one of these protests, or do something that unduly besmirches your employer's reputation, then it can be just cause. So the classic example that I used at the interview that I did on the radio was the guy who slowly drove his truck into a protester. That's assault. And at that point, I think that would have been just cause. And I don't know if he was also in a company truck at the time. So that to me would have been likely been just cause. So we would have had no severance. But just remember, can your employer fire you for being at the protest? Well, your employer can fire you for anything. What matters is, well, I shouldn't say anything. It can't fire you for human rights reasons and so forth. They can't fire you because of your race or your ethnicity or gender or what have you. But they can fire you because they don't like your shoes. But you're going to be owed severance in that situation. Your only legal right in the event of your termination is severance, pursuant to whatever your legal position is. So it's a question to think about. If you've got a sensitive employer with that, then you probably don't want to be at one of those protests. But as of yet, you don't lose your right to severance because of your political beliefs. As of yet. Julia asks, I've been at my current job for 3 years, but never signed an employment contract. It's a good position to be in. Should I request one? That's a good question. So that I can have my position outlined? Absolutely 100% no. Okay. So what an employment contract is it's not for your benefit at all. It's for your employer's benefit. It is the employer exploiting its superior bargaining power over the employee at the time of contract formation to force or induce the employee to agree to terms contrary to the employee's best interests as against the employer. It's not there for you. It's there for the employer in like 99% of situations. So no employment contract means in the event of your termination, you automatically get common law severance, which is a 4 times multiple, give or take, from what you get under the Employment Standards Act. So the Employment Standards Act, you've been there for 3 years, you get 2 weeks of severance. At common law, 2 to 3 months. If you're in your senior position, 4 to 5 months. If you're in BC, and if you're unemployed for a long time after that, it can escalate from there up to, I think Corey and Kruger was 8 months was awarded. So, you never no. The only time you definitely want your employer to force you to sign to outline the terms of your contract. Your contract of employment in a written employment contract is if you are a high valued employee that has lots of leverage and you want to craft for yourself a golden parachute and structure your bonuses accordingly. I had to talk to somebody about that last week or the week before, actually. That's the only situation. If you've got a high amount of leverage, sure. So executives, high paid scientists, that kind of thing, general managers, maybe they can do that, right? But for your average rank and file employee, no. If they haven't made you sign a contract, do not sign them, or do not ask for one. This is Julie again. Who benefits more from an employment contract? I'm worried that they could claim my position is different than reality if I don't have it in writing. Well, sure they can, but they're not going to Remember, your only legal right in the event of your termination is severance. Okay, and so they're not going to be able to say that there was a written employment contract that limits your severance to something other than common law notice. Common law notice gives you sort of the largest severance you can get absent setting out something specifically in your contract. So you, Julia, by not having an employment contract, are in a much better position than if you had one. Okay, so don't ask them to do it. To answer the first part of your question, your second question, who benefits from an employment contract? More of an employment, your employer. Your employer is the person who wants the employment contract to limit your rights. Oh, Julia again, and then we're almost done. I'm a middle management employee with the company and do a lot of different work for them. Yeah, I mean, middle management, that's going to have an elevating effect on your floor of severance. You've been there for a couple, 2-3 years. 3 years, I think, is what you said, or just a little shy of 3 years. So yeah, no, you don't want an employment contract. Just keep working without one. And Julia, I think here's the thing that you need to think about. If your employer figures out, hey, Julia doesn't have an employment contract, let's get her to sign an employment contract. Then you need to decide if you actually want to sign one. Right? Because that employment contract is going to take your right to common law severance, i.e. 24 months of pay on termination at the very high end if you've been there for many years, and shrink it down to a maximum of 8 weeks. Totally eviscerates your rights. And so would you want to sign it? I would say no, but just understand if you don't sign it, they might fire you for not signing it, and then you'd be entitled to the severance that you currently would be entitled to at that moment in time. So if, Julia, I'll leave you on this one. If your employer asks you to sign an employment contract at some point, don't sign it without talking to a lawyer. And that's a perfect segue into wrapping this up. And we got through every question today, which is the first time that's happened. Employmentlawyer.ca, you can reach us. help@employmentlawyer.ca. You can call us at 1-855-821-5900. Thank you for all your questions. Join us again live with the wonderfully named Chris Justice on March 7th. March 7th, he'll be laying down the employment law for you on March 7th. So join us for that. And thank you all for your questions. I hope you have a wonderful weekend. I will be back in 2 weeks. Please join me for that again. We'll be talking about all things vaccine mandates and maybe some other questions as well. So thank you all for your questions. Have a wonderful weekend. And